Welcome back, everyone. In the previous lecture, we studied the foundation of valid Hindu marriage. We looked at section 5, all its 5 subclauses, section 7 dealing with ceremonies, and finally section 17 dealing with bigamy consequences. So by now, we already know that a valid Hindu marriage is not merely a matter of social recognition or ceremony. Legally speaking, a marriage under Hindu Marriage Act is valid only when it fulfills statutory condition prescribed by the act and is properly solemnized. This leads us to a what if question. What if something is wrong with the marriage? Suppose one party already has a spouse living. Suppose the parties were within a prohibited relationship. Or perhaps consent might have been obtained through fraud, or there might have been non-consummation of marriage. One party might also be below the statutory age. Can we jump straight to the conclusion saying that the marriage is void? Or it is more accurate to say the marriage is voidable? Or perhaps there is a third possibility that although the defect is serious, the marriage does not fall within either categories prescribed under section 11 and 12. That is the point of exploration of today's lecture. Today, we will not see this question only academically, but we'll also learn how the practicing advocates and court dissects a defective Hindu marriage. The central question is that where is the defect expressly mentioned in Hindu Marriage Act? A marriage may be defective in many ways, but the consequence depends on the statutory location of that defect. Think like an advocate for a moment. A client usually comes in and he comes in with a practical concern saying something like, "Sir, I'm having serious problems with my marriage and I want to know what I can do legally." You should not jump to any conclusion at this stage. Instead, you must first gather all the relevant facts from the client completely and carefully. Your first response should be to ask structured questions. Is there a defect in the marriage? If yes, what exactly is the defect? Does it relate to bigamy or prohibited relationship or Sapinda relationship? Was there any fraud or coercion involved? Were the parties mentally capable at the time of marriage? Is there any allegation of pregnancy by another person? Was the marriage within legally permissible age for both the bride as well as the groom? Each of these defects travel on different legal roads. Section 11 deals with void marriages. Section 12, on the other hand, deals with voidable marriages. And some defects may fall outside of both Section 11 and 12. That is why the takeaway is important. Start with what Hindu Marriage Act says, not with presumptions or societal notions. In law, presumptions and notions can be misleading. The statute is the only roadmap. Now let us convert this into a decision tree. When a court is asked to deal with a defective marriage, it should move in following 4 steps. The first step is to identify the defect. This is where pleadings matter. A vague pleading, for example, the marriage is illegal or the marriage is invalid, this is not enough. A lawyer must ask what exactly is being alleged. Secondly, check section 11. Section 11 does not cover every defect. It covers only 3 violations, that is violation of section 5, subclause 1, subclause 4 and subclause 5. That means if the spouse is living during subsistence of the marriage, or the marriage is within prohibited relationship or within Sapinda relationship. Thirdly, check section 12. Section 12 deals with voidable grounds. This includes non-consummation owing to impotence or contravention of section 5 subclause 2, coercion, fraud and pregnancy by another person. Fourthly and finally, if none of the sections, that is section 11 and section 12, do not apply, do not force it there. A serious defect may still require a remedy, but the remedy may lie somewhere else. This is where many legal mistakes happen. We try to fit every defect in a marriage into the same box, but the law does not work like that. You cannot fit a round peg into a square hole and expect the court to accept it. Now let us look at the three possible outcomes. Outcome A is void marriage. A void marriage has a root defect. It is treated as nullity, that is null and void from the beginning. The decree may be declaratory in nature, but practically it becomes very important for status, property, succession, remarriage, and sometimes for criminal consequences. Outcome B is voidable marriage. A voidable marriage is not automatically invalid. It remains valid until annulled by a decree of nullity. This is a very important distinction. A voidable marriage gives the aggrieved party a choice, but if that choice is not exercised, the right may be lost. And finally, outcome C. Outcome C is that it is neither a void nor a voidable marriage. This is often ignored. A defect may be serious, but if parliamentarians have decided not to place it in section 11 or 12, the court cannot casually declare it void or voidable under those provisions. For example, a breach of the age condition under section 5 subclause 3 has serious legal consequences under appropriate child marriage laws. But under section 11 of Hindu Marriage Act, it does not treat a marriage as void. So the court first classifies the defect and then gives the consequence. The cart cannot be put before the horse. Now let us read section 11 carefully. Section 11 says that any marriage solemnized after the commencement of this act, any marriage solemnized after the commencement of this act shall be null and void and may, on a petition presented by either party thereto against the other party, be so declared by a decree of nullity if it contravenes any one of the following specified condition in clauses 1, 4 and 5 of section 5. Notice what the section says. It does not say if section 5 is breached, the marriage is void. All it says is that only clauses 1, 4 and 5 of section 5. This is the key. A lawyer must train the eye to notice what the statute includes and what the statute leaves out. Now let us observe the three grounds given in section 11. One is polygamy, another is prohibited relation, and third is subpinda relationship. So only section 5 subclause 1, 4 and subclause 5 are given over here. Subclause section 5 clause 2 and section 5 subclause 3 observe are missing over here. So in these two cases of clause 2 and clause 3, the marriage is definitely not void because it is not given under section 11. Not every breach of section 5 makes marriage void under section 11. Section 5 clause 3, which sets the age requirement, is also not treated as a ground for nullity under section 11 or 12. So while the age violation may have equal consequences, it does not by itself make the marriage void or voidable under these provisions. Now we come to a very practical point. A marriage may be void in substance, but the petitioner must still choose the correct legal procedure. Take this one example. A husband has a living wife. He then contracts a second marriage while she is alive and he has not divorced her or she has not died. The second marriage may be void under section 11 in this case. Section 11 read with section 5 clause 1 will make such a marriage void. Now the first wife wants to challenge the second marriage. Can she directly file a section 11 petition? This is where many people speak too broadly. Section 11 speaks of petition by either party to that marriage against the other party. But the first wife is not a party to the second marriage. So her remedy cannot be a direct section 11 petition. She may first need a declaratory relief under general civil law, especially if her civil status, such as inheritance, maintenance, property rights, or marital status, are affected. This is not merely a technical point, this is a very important procedural point that bridges the gap between a right and remedy. A right without the correct procedure is like having a correct destination but choosing the wrong road. Now let us move to section 12. Section 12 deals with voidable marriage, as we already discussed. A voidable marriage is different from a void marriage. It is not automatically treated as nullity, it remains valid unless annulled by a decree of nullity by the aggrieved party. Now understand that section 12 is not a general remedy for every disappointing marriage. This principle must be clearly understood. A marriage that has failed does not by the fact alone become voidable. A marriage that proves difficult or strained does not on that basis qualify as voidable. Similarly, a change in a spouse's behavior after marriage does not amount to a fraud. The petitioner must fit the case within the statutory ground. Under section 12(1)(a), which talks about impotence, the law specifically deals with non-consummation of marriage due to impotence of the respondent. This provision requires two essential elements to be established. First is that the marriage should not have been consummated, and the second is that such non-consummation should be directly attributable to the impotence of the respondent. It is not sufficient for the petitioner to merely state that consummation did not occur. The petitioner must clearly demonstrate that the failure to consummate the marriage was caused by the respondent's impotence. There are two elements to it: non-consummation and a legally recognized cause, which must be established together. And under section 12(1)(b), which talks about capacity or mental capacity, the marriage is voidable if it contravenes a condition specified in section 5 clause 2. This means that if at the time of marriage either party was incapable of giving valid consent due to unsoundness of mind, or was suffering from a mental disorder of such a kind or extent as to be unfit for the marriage or procreation of children, or had recurrent or the party had recurrent attacks of insanity, the marriage does not become automatically void but can be annulled at the option of the aggrieved party. Now turning to section 12(1)(c), which talks about consent. Section 12(1)(c) requires that the force or fraud must be connected either to the very nature of the marriage ceremony itself or to a significant fact or circumstance relating to the respondent. Therefore, the inquiry is not limited to asking was there a misrepresentation, but rather the court will consider whether the fact was important enough to affect the decision to marry. Did it relate directly to the respondent? And did it actually influence the petitioner's consent to the marriage? This is how a presiding officer in a court will frame the issues. The last ground in is section 12(1)(d), which deals with pregnancy by another person. Now, voidable relief has another layer to it. Section 12 relief is controlled by limitation, knowledge, discovery, and conduct. In the case of allegation of involvement of force or fraud, the petition must be brought within the statutory period after the force ceased or after the fraud was discovered. And there is another important bar, that if after discovering the fraud, the petitioner voluntarily lives with the other party as husband or wife, the court may treat that conduct as affirmation of the marriage. So ask yourself, can a person discover the fraud, continue the relationship, and then years later claim nullity of the marriage? The law does not permit that. Voidable marriages give an option, but that option must be exercised properly and within due time. This reflects the doctrine of laches. The law assists those who are vigilant, not those who are sleeping over their rights. If a person unreasonably delays in asserting a right and that delay prejudices the other party, the court may refuse the relief altogether. For pregnancy by another person, also the petitioner must satisfy strict requirement as laid down under section 12(1)(d) read with section 12(2). The petitioner must prove that at the time of marriage, the respondent was already pregnant by a person other than the petitioner and that the petitioner was completely ignorant of this fact at the time of marriage. Mere suspicion or later discovery is not sufficient. The burden lies with the petitioner to establish both the fact of the pregnancy and lack of knowledge at the relevant time of marriage. Additionally, the petition must also be presented within 1 year of marriage, reflecting the legislative intent that such grievances must be raised without undue delay. Further, the petitioner must also show that after discovering the fact of such pregnancy, there was no voluntary marital intercourse with the respondent. If the petitioner, after gaining the knowledge, continues to cohabit or engage in marital relationships and intercourse with the respondent, then the law treats it as a condonation, thereby barring the relief. So in section 12 case, facts, conduct of the party and the time after discovery all become very important. Now let us look at the third possibility, that there is a defect in a marriage and it does not fall under section 11 as well as section 12. And the perfect example of this is section 5 subclause 3, which talks about the age requirement of 21 years for the bridegroom and 18 years for the bride. Section 11 does not mention anything about section 5(3), and section 12 also does not generally treat age breach alone as a ground for voidability. Therefore, under section 11 as well as 12, age breach is not automatic nullity. This does not mean that age does not matter. Of course, age does matter in a marriage. Child marriage is also an offense, but it may matter under child marriage law. It may attract other penal consequences. It may create separate remedies, but under this specific Hindu Marriage Act section 11 and 12, we cannot simply say that age condition, if it is breached, therefore marriage is void or voidable. In fact, this is the line of reasoning that was relied in the case of Manish Singh versus Delhi NCT. Manish Singh versus Delhi NCT. In this case, the principle was clearly established that you have to read the exact statutory consequence as it is given in the act, and you cannot start adding new grounds into section 11 and 12 just because it feels fair to do so. In other words, the court must resist the temptation to expand the scope of this provision based on the perceived fairness or policy consideration. The legislature has deliberately chosen which defects will render a marriage as void and which will make a marriage voidable. And that choice of the legislature must be respected. If a particular defect, such as a breach of age requirement, is not expressly included within section 11 and 12, the court cannot by interpretation treat it as falling within those categories. Instead, the court must look to the appropriate statutory framework that governs that defect and apply the remedies provided there. This disciplined approach ensures consistency and it prevents judicial overreach and maintains the integrity of the statutory scheme. For a lawyer, this is very crucial point. Do not argue what the law should have been doing. Argue what the law actually says and then find the correct remedy. Let's now quickly revise. Void marriage comes from section 11. It involves a root defect. A decree may be declaratory, but it is practically very important. Next comes voidable marriage. A voidable marriage means a marriage is valid until it is annulled. Delay, knowledge, conduct, and cohabitation may matter. The third category involves neither void nor voidable marriage, that is, neither section 11 or 12 applies. There may be other consequences, but you must identify the correct remedy, as in the example of Prevention of Child Marriage Act in the case of age of children. So when a client comes to you, they won't ask you in legal terms, or they won't neatly list out the issues to you. They will ask you something vague like, something is wrong with my marriage, or I have discovered that I was misled during my marriage. Your job is to translate that into legal questions. What exactly went wrong? Which part of the law does it fall under? What does the act prescribe in such a situation? Who has the locus standi, meaning who can actually file the case? Is there any statutory time period within which the case must be filed? And is the client within the statutory period from the date of knowledge of such a fraud or misrepresentation in his or her marriage? And is the available proof sufficient and credible enough and legally admissible to be relied upon in the court of law? That is a lawyer's approach. Law is not a maze without direction. There is a step-by-step method to address each issue, and every grievance must be addressed through appropriate legal provisions. Now let us come to case laws. The first one is of Srimati Ram Pyari versus Dharamdas. This case is from Allahabad High Court from the year of 1983. So the facts of this case are, it was not just a private husband and wife dispute. The issue arose in a succession proceeding after the death of Tularam. Ram Pyari approached the court claiming a succession certificate on the basis that she was legally wedded wife and therefore was entitled to inherit the estate owned by Tularam. Her claim was opposed by other claimants of the estate, typically the relatives and the person asserting inheritance right over the estate. So the question that arose in this dispute before the court was whether a valid marriage had ever taken place between Ram Pyari and Tularam. The court had to examine evidence relating to the alleged marriage, such as ceremonies, cohabitation, and recognition, because the answer to the question would determine who was legally entitled to succeed to the deceased Tularam's property. The court held that Ram Pyari had failed to establish the existence of a valid marriage with Tularam, as the evidence regarding essential ceremonies and the recognition was insufficient. Consequently, she was not entitled to claim succession as his legally wedded wife. This case gives an example why proving validity of a marriage is important, because voidness may affect status, succession, property rights, and even inheritance. The marriage is not merely a personal relationship, it can be a legal foundation for several civil rights as well. If that foundation is shaky, parties whose rights are affected may challenge it. Secondly comes the case of Ajay Chandrakar versus Usha Bai. In this case, the first wife approached the court alleging that her husband had contracted a second marriage during the subsistence of their valid first marriage. She sought to challenge the validity of that second marriage by invoking Section 11 of the Hindu Marriage Act. However, the difficulty before the court was that Section 11 allows a petition of nullity to be filed only by either party to the marriage in question. The court clarified that although the second marriage could be void in substance due to violation of Section 5, Clause 1, since she was not party to the second marriage, she could not use Section 11. Instead, her proper remedy was to seek a declaration from a competent civil court that the second marriage was void, especially where her own civil rights, such as marital status, maintenance, and property rights, were affected. Ultimately, the court established that the route chosen by the first wife was legally inappropriate under Section 11, even though her substantive claim about the invalidity of the second marriage could be correct. The case reinforces a crucial lesson. Even a substantively strong case needs a proper procedural compliance. Now, in our previous lecture, we already discussed Sarla Mudgal case in great details. So, we will not go into detail and the facts of that case, but I would like to say that in earlier lecture, we discussed Section 5, Clause 1, Section 17 and bigamy consequences. Here we connect that discussion with civil nullity. Lily Thomas versus Union of India, the case from Supreme Court year 2000. There are many Lily Thomas cases with the same name, so you must reproduce and remember the year, because that will important to differentiate between which Lily Thomas case you are talking about. So in this case, the principle laid down is that conversion does not automatically dissolve a subsisting Hindu marriage. A spouse cannot convert and say that I am eligible for a lawful bigamy since I am governed by a different personal law now. That is not how law operates. If the first marriage continues and the spouse contracts another marriage, Section 5, Clause 1 is violated. The latter marriage is null and void, and criminal consequences may also arise where the ingredients of bigamy are proven. But remember, we are using these cases only as a bridge. The deeper bigamy discussion belongs to the previous lecture where we have covered this in great details. Today's limited point that I am trying to make here is that Section 5 Clause 1, if it is violated, then Section 11 steps in where the marriage becomes void. Now we come to fraud. Fraud is one of the most misunderstood grounds. In matrimonial law, a marriage becomes voidable on the ground of fraud only when the statutory requirements under Section 12(1)(c) are strictly satisfied. The fraud must relate either to the nature of the ceremony or to the material fact of the circumstances concerning the respondent. It must also have induced the petitioner's consent to the marriage. Let us look at two different comparative cases. One is that of Anurag Anand versus Sunita Anand, which is from Delhi High Court, and the year is 1996. In this case, the dispute arose out of the arranged marriage where the husband alleged that the wife and her family had made false representation in matrimonial biodata prior to the marriage. It was claimed that the incorrect information had been provided regarding her salary, date of birth, and financial status, and that these representation had induced him to consent to the marriage. The court examined whether these statements amounted to fraud under Section 12(1)(c). The court observed that not every incorrect or exaggerated statement in a matrimonial negotiation would amount to a legal fraud. The key question was whether misrepresentation related to the material fact concerning the respondent and whether it had a direct bearing on the consent of the petitioner. On the facts, the court found that alleged discrepancies did not rise to the level of material misrepresentation sufficient to vitiate the consent of the appellant. There was no clear evidence that the petitioner's consent was obtained by deception of such a nature as to justify annulment. Accordingly, the court held that the requirements of fraud under Section 12(1)(c) were not satisfied and the marriage could not be annulled on that grounds. What we learn from this case is that not every false statement or discrepancy amounts to legal fraud. Only material misrepresentation that directly affects the consent can justify annulment under Section 12(1)(c) of Hindu Marriage Act. Now let us see another case, that is of Sundarlal Soni versus Namita Jain, which is from the year 2005 from Madhya Pradesh High Court. In the earlier Anurag Anand case that we discussed, the alleged fraud was not of the nature to affect the consent, But in contrast, in this Sundarlal Soni case, this case represents a more complex situation where the fraud was not merely confined to the single false statement but involved a broader pattern of conduct and circumstances that heavily influenced consent. In this case, the husband alleged that the marriage was brought about through a combination of misleading practices related to astrology. There were claims that bride side used astrological predictions and created a sense of urgency and fear to push the marriage forward. It was also alleged that important facts were concealed, such as the true age of the bride and the existence of her major child from previous relationship. These were not isolated misstatements, but a part of a larger narrative constructed to secure the husband's consent to the marriage. What makes this case significant is that it shows how fraud under 12(1)(c) can arise not only from direct false representations but also from an environment that is of deception. When we compare this with the case of Anurag Anand, we understand that the two models of fraud, one is based on specific false and exaggerated statement, and another is based on concealment, pressure, and misleading circumstances. The key takeaway is that for fraud to be legally significant under Section 12(1)(c), it must relate to the material fact or circumstances governing the respondent and it must have actually influenced the consent given by the petitioner. Whether it is a single false statement or a broader pattern of deception, the court will examine whether the misrepresentation or concealment was material and whether it influenced the marriage. This is how Section 12 fraud must be approached at. Now we need to understand that every concealment does not amount to a fraud. Every unpleasant post-marriage discovery is not a fraud, and every disappointment is not a legal ground for nullity. The case at hand is Madhusudan versus Chandrika from MP High Court from the year 1975. This case is useful as a boundary case. In this case, the husband sought annulment on the ground that wife had concealed that she was suffering from syphilis. Syphilis is a sexually transmitted infection caused by bacteria which can be treated and which can be cured with proper medical care, especially if it is detected in early stage. So the court examined whether such concealment amounted to fraud under Section 12(1)(c). It was held that mere non-disclosure of a disease, particularly one that is curable and not shown to have fundamentally affected the marital life at the time of marriage, did not amount to the level of fraud that would vitiate the consent. The court emphasized that not every omission or not every disclosure would qualify as a fraud. The concealment must go to the root of the marital relationship or the nature of the consent that was obtained. Now this case must be handled very carefully because later in 1976 there was amendment. Prior to the amendment, the scope of fraud was narrower. It was confined to the nature of the ceremony or identity. The 1976 amendment expanded the scope of Section 12(1)(c) and it also included the fraud as to any material fact or circumstances concerning the respondent. However, even after the amendments, the court have not treated every concealment as sufficient for annulment. The current judicial approach relies on the reasonable person test, meaning court asks whether the concealed fact was so significant that an ordinary prudent person in the position of the petitioner would have refused consent if they had known the truth. This shifts the focus away from the subjective feelings of the petitioner to an objective standard, ensuring that only genuinely material misrepresentations, those that would affect the decision making of a reasonable individual, qualify as a fraud under law. Courts also examined whether the condition was seriously incurable or likely to affect marital relationship in substantive way, and whether there was a deliberate intention on part of the respondent. Thus, while Madhusudan versus Chandrika reflects a pre-amendment restrictive approach, its core teaching still survives. Not every non-disclosure amounts to a fraud. Now let us discuss impotence and non-consummation. Section 12(1)(a) requires proof that the marriage has not been consummated owing to the impotence of the respondent. That means non-consummation alone is not enough. There must also be a legally established connection between non-consummation and a respondent's impotence. The case at hand is V. Shankar Ram versus Sukanya. This case was before the Madras High Court in the year 1997. The facts were that the husband in this case approached the court seeking annulment of a marriage under section 12(1)(a) of Hindu Marriage Act. He alleged that after the marriage the relationship did not develop in the expected manner. According to him, there was a lack of domestic adjustment between the parties, differences in personality, and the general failure of marital expectations. He further claimed that the wife was more inclined towards her musical pursuits and she showed little interest in marital life. Most importantly, he alleged that the marriage had not been consummated. However, the court carefully examined these allegations and found that they were largely based on subjective dissatisfaction rather than really relevant on ground. The court observed that mere non-consummation of marriage is not sufficient to grant a decree of nullity under section 12(1)(a). The statute specifically requires that non-consummation must be owing to the impotence of the respondent. In this case, the husband failed to establish that allegations of non-consummation was due to any physical or psychological incapacity which was amounting to impotence on the part of her wife. The court emphasized that allegations such as incompatibility, lack of interest, differing in opinions, or having different priorities, all these things do not automatically translate into legal impotence. There must be clear, cogent, and convincing evidence to show that the respondent was incapable of consummating the marriage. Since no such evidence was produced before the court refused to grant annulment. Legally, section 12(1)(a) sets a strict standard. It is not enough to show that the marriage was not consummated. The petitioner must also prove a direct link between non-consummation and the respondent's impotence. This requirement ensures that the provision is not misused to dissolve marriages based on ordinary discord and small quarrels and petty issues. Now we come to the consequences, and this is where the law becomes both sensitive as well as practical. The marriage may be void or voidable, but what about children? The law is very clear that welfare of children is the central concern, and the child should not suffer because the defects in the parents' marriage exist. Section 16 is important because it separates the invalidity of marriage from the legitimacy and protection of children. The idea is very simple. Even if the marriage is legally defective, the child should not be treated as illegitimate in a way that harms their dignity, status, or basic rights. In a void marriage, the child is protected whether or not a decree of nullity is granted. This means that even if the marriage is treated as it never existed, the child is still recognized as legitimate for the legal purpose. In a voidable marriage, where a decree of nullity is passed, children begotten or conceived before the decree are protected. So until the marriage is annulled, it is treated as a valid, and children born during the period are fully protected. This reflects a broader principle. The law gives priority to the welfare of child, and it does not give any importance to the technical defects in the marriage and relationship as far as the welfare of the child is concerned. Courts are generally guided by the idea that a child should have stability, identity, and access to parental support regardless of the disputes between the parents. Now let us come to the property rights. Property rights of a children born out of a void or voidable marriage. Section 16 protects legitimacy, but it places a clear limitation on the property rights. The child is entitled to inherit from the parents, that is, from the property of mother and father. However, this protection does not automatically extend to the property of other relatives, such as grandparents or members of joint Hindu family. To make this concrete, consider two situations. First, suppose a father owns a self-acquired house in his own name. A child born from a void marriage can inherit that house upon father's death, just like any other legitimate child. Similarly, if mother owns a bank deposit or land in her own individual capacity, the child can claim a share in that property. Now contrast this with a joint Hindu family scenario. Suppose the father is a co-partner in a joint Hindu family that owns a ancestral agricultural land shared with his brothers. The child from a void or voidable marriage does not automatically become a co-partner in a joint Hindu family property. Therefore, the child cannot demand partition of that ancestral land as a matter of right in the same way a co-partner could have. The child's claim is generally confined to the father's share, and even that may arise only when the father's interest is separated from the entire joint estate. So the key point over here is that section 16 ensures that the child is not denied inheritance from parents, but at the same time it does not automatically elevate the child to the status of a co-partner in a joint Hindu family property. This distinction is important because it balances two concerns: protecting the child's basic rights and status while also protecting the established rules of succession and family property structures. Therefore, we must keep three things separate in our analysis. First, the validity of marriage. Second, the legitimacy and welfare of the child. And third, the extent of property rights available to that child. Now, if you don't remember each and everything from this lecture, just follow me in this checklist. Before arguing the nullity of a marriage, move step by step, one by one in this checklist. First, identify the exact defect. Identify the defect. Second, check whether any ground in section 11 applies. Then, thirdly, if no ground under 11 applies, move to section 12. Fourthly, if section 12 applies, check for limitation, knowledge and conduct related rules that applies to both the parties. Fifthly, I would say, choose the correct procedural route. And finally, check the status of legitimacy of children and devolution of property upon children born after void or voidable marriage. This checklist is very useful in real life practice. A poorly drafted nullity petition may fail not because the facts are weak, but because the statutory route is wrong. Now let us revise the legal principle that was behind each and every case that we discussed in this particular lecture. First comes the case of Ram Pyari that was related to succession and status. The principle here was that validity of a marriage is not confined to personal relationship between spouses. It has wider civil consequences. When a person claims rights such as inheritance, maintenance or succession based on marital status, the court must first examine whether the marriage itself was legally valid or not. Next comes Ajay Chandarkar case, which is about third party procedural route. The principle is that legal remedies must follow proper procedural channels. Even if a marriage is void in substance, only the parties to the marriage can directly invoke section 11. A third party, such as a first spouse, must seek declaratory relief through appropriate civil proceedings. This case highlights that substantive rights and procedural mechanism must align, otherwise, even a claim that is legitimate may fail. Lily Thomas is about conversion and bigamy. The principle established is that conversion of religion does not automatically dissolve an existing marriage. A subsisting marriage under Hindu law continues unless legally dissolved, and any other subsequent marriage during its subsistence is violation of Section 5, Clause 1. This reinforces the rule of monogamy and prevents misuse of religious conversions as a device to circumvent matrimonial obligations. Next comes the case of Anurag Anand, which is about biodata fraud. The principle here is that misrepresentation in matrimonial negotiations can amount to a fraud only if it relates to a material fact concerning the respondent and it induces the consent of the petitioner. Next comes Sundarlal Soni case, which is about concealment, influence, and the constructed fraudulent environment. The principle is that a fraud may not always be a single false statement. It can arise from combination of concealment, misrepresentation, and psychological influence that together distort free consent. Next comes the case of Shankar Ram. Shankar Ram is about proof of impotence. The principle is that allegations under section 12(1)(a) require strict proof. Non-consummation alone is insufficient. It must be shown that failure to consummate is directly attributable to the respondent's impotence. Finally comes the case of Manish Singh. Manish Singh is about age breach not automatically falling within section 11 or 12. The principle is that not every violation of section 5 leads to nullity or voidability under the Hindu Marriage Act. So that was a summary of all the cases that we discussed in this particular lecture, along with the principle established or reaffirmed in each case. So the summary of this entire lecture is that you need to go step by step to understand how the marriage is defective as per Hindu Marriage Act. First, you have to identify the defect. You have to locate it in section 11 or section 12. And if it is not found in both places, then you have to find out the correct remedy elsewhere if available. Determining the fate of a defective marriage requires a close reading of section 11 and 12 along with section 5 clause by clause. This is why today's lecture is so important. In the previous lecture, we learned how Hindu marriage becomes valid. Section 5 talks about conditions of marriage, Section 7 talks about ceremonies, and Section 6 talks about consequences of bigamy. In this lecture, we examined what happens when a validity of a marriage is challenged, whether it is voidable, or neither voidable. I want to leave you with a real story now. An actress left her husband and chose to live separately. Her husband then went to court claiming that his wife had left him without a valid reason and asked the court to order her to return and live with him again. This kind of relief is known in law as restitution of conjugal rights, and it is a remedy under Section 9 of Hindu Marriage Act. The wife, however, did not simply accept this claim. Instead, she challenged the very idea that court could direct one spouse to resume cohabitation with other. She argued that such direction interferes with personal choices and raises serious concern about individual freedom, dignity, and autonomy within marital life. The court examined these arguments carefully and engaged with a broader question of how far law can go in regulating intimate marital relationships. The court considered this kind of order as something that could pressure a person to return to a marital relationship against their own will, raising concern about personal liberty and autonomy. Was this a progressive step towards protecting individual autonomy? Or did the court go too far in dismantling a long standing matrimonial remedy? Is this judgment correct according to you? What is the current legal position on this issue and why does it continue to divide opinions? We will explore this remedy of restitution of conjugal rights in detail in next video.